Morning, everyone. Just waiting a couple of seconds for people to join in, get the tech warmed up. So, very good morning to you all, and welcome to the latest webinar from the Walker Morris Employment and Immigration teams. So today we're going to be looking at the concept of immigration and workforce management in an increasingly remote but globalised world of work. My name is Andrew Raymond. I work in the employment team at Walker Morris. And given the topic we're looking at, I'm helpfully joined by my colleagues Shabana Munir and Katerina Woodcock. Both of those are specialists in employment. Employment and immigration, I should say, but with a particular focus on immigration. And they've got huge experience in helping clients navigate through sort of immigration systems. As you can imagine, they've been particularly busy in the last few months. So today we're going to look at looking to provide practical advice on recent and upcoming changes to the UK immigration requirements. Many of those have particular significance as we are in this sort of post-Brexit world and looking at EU nationals. What's the big impact on those? And we believe that this is of relevance to basically anyone involved in recruiting and keeping overseas workers, and also dealing with the management of remote workers. So in the session, we're going to cover the EU settlement scheme, particularly recognising that the deadline has now passed. How do we deal with missed applications? Secondly, we're going to look at the current position on right to work checks. Again, a bit of a moving target. COVID concessions and new checks which came in on the 1st of July this year, so it's all pretty fresh stuff. Then we're going to have a look at EU and non-EU workers coming in and working in the UK. What's the position for those? And then we're also going to have a quick look at sort of how to manage people, actually not only foreign nationals, but also people working remotely who are UK nationals. In terms of practicalities, we're going to divide things up between us so that we can allow time for questions. The plan is to try to sort of finish things by sort of 9:45, but we've got the session till 10, so we've got a bit of flexibility to deal with questions. And in terms of questions, I think many of us are now familiar with this technology. On your screen, you should have a Q&A function. Therefore, you can add in questions as you go along, and then my job towards the end is try to collate those and sort of put the questions back to the most relevant person on the talk. If we can't get to a particular question in this session, we will come back to you. So don't feel shy. Do ask the questions. So hopefully that's clear, and hopefully we have a good session. So in terms of getting us started, perhaps I could ask Shabana about some of the key sort of recent immigration changes that we need to be aware of, because I guess we've all seen that the deadline for applying for status under the EU settlement scheme expired on the 30th of June, i.e. last month. And I've read that the Home Office has had about 6 million applications up to the deadline. It makes you think, oh my word, how are they dealing with that? But what happens if someone has missed the deadline? Is that it? Can they still apply?
So first of all, I think for the benefit of those who aren't familiar with the EU settlement scheme, this is effectively the scheme that was set up by the government to protect the rights of European nationals who were already in the UK as at the end of the Brexit transition period. So that's the end of December 2020. And when I talk about European nationals here, what I technically mean is nationals from the EU, the EEA and Switzerland. But that is a bit of a mouthful, so I'm just going to refer to European nationals throughout. So this is a scheme that was intended to protect their rights, their residency rights. and European nationals were given a grace period and required to make an application for residency status by the 30th of June 2021. If, when they made their application, they could evidence 5 years continuous residence in the UK at that point, then they were granted what's known as settled status, which is the indefinite right to continue living and working in the UK, subject to some criteria. If they had less than 5 years residence at that point, then they were granted what's known as pre-settled status, which is effectively a time-limited right to live and work for another 5 years up until they acquire the requisite 5 years for settled status. But turning to your specific question, whether can applications still be made? In short, the answer is yes. The online portal through which applications to the settlement scheme are made is very much still open, and there are certain circumstances which allow for applications to be made, even though the 30th of June deadline has now passed.
Okay, so that's a piece of good news in terms of it's not completely closed. So I guess someone who's late, what have they got to do? What should they be doing?
So effectively, if an eligible individual missed the deadline, but can show that they've got reasonable grounds for why they missed that deadline, then there is still the option of making an application. The Home Office has given some guidance on what they think will constitute reasonable grounds, and they refer to things like somebody who's ill, somebody who isn't aware of the fact that there is a requirement to make the application to protect their residency rights, somebody who hasn't had internet access because the application is made online, so somebody who doesn't have the technology to assist with that, somebody who hasn't been able to due to COVID, for example. But late applications will be considered for other compelling reasons as well, provided that evidence can be provided at that time. I think the key thing for employers to be aware of is that there are now practical transitional measures which have been put in place up until the end of December 2021 in relation to those employees who were in their employment as at the 30th of June 2021, but who have failed to apply under the settlement scheme by this date. And these transitional measures effectively provide employers with a formal process to assist employees with making their application within a 28-day time frame without having to terminate their employment, which they might otherwise would have had to do. I think what I would stress at this point is that the transitional measures only apply to people who were in employment as at the 30th of June. For somebody who comes into your employment from the 1st of July onwards, these provisions aren't then available.
Okay, so that's interesting, because I've seen and I've heard from clients, the usual concern that if someone, if an employer knows about someone not having the right to be here, they can get into sort of all manner of hot water. So that's moved then, has it? You're mute.
Until the transitional measures were published, and they were only published on the 1st of July, so we've not known about these for very long at all. Before then, the thinking was very much along the lines you've just outlined. And there was a bit of a grey area in all of the various Home Office guidance about what does an employer do in the scenario where they become aware that somebody hasn't made an application under the EU settlement scheme in time. Are they then liable for criminal penalties? Because there are criminal sanctions against knowing somebody who's employing an illegal worker. And the Home Office guidance previously hadn't specifically addressed this point. But what they now do is effectively provide the employer with an additional 6-month window in which to really do some due diligence, identify anybody within the organisation who might fall within the transitional measures, and then take them through the requisite process. So just in order to take advantage of the measures, what an employer will need to do is firstly advise the individual that they were required to make an application, they haven't done so in time, and that they can make a late application within 28 days, and then provide the employer with what's known as a certificate of application, i.e. evidence that the application has been made. If at that point the employer doesn't receive a certificate of application, then the employer should commence termination proceedings, i.e. at that point they do know that there is somebody without the right to work and that person hasn't taken advantage of the transitional measures. But what I would do is put a bit of a health warning on that and say, if you are in that situation where you're having to consider termination, always take legal advice on that, because there are all manner of risks around unfair dismissal and discrimination. So it's never going to be an easy one to navigate. If, on the other hand, the employee at that point does present the certificate of application, then the employer needs to contact the employer check-in service for what's known as a positive verification notice, or a PVN. And they then effectively, that PVN gives them a 6 months right to continue employing the individual, and then the employer has to do a repeat check for another PVN before its expiry, effectively, to keep within that safe environment. The other thing employers, I guess, should be aware of is that in terms of applications out of time, family members who've arrived in the UK after the 1st of April, who have a family member in the UK who's made an application under the EU settlement scheme, will continue to have the right to make a late application, provided they've come into the UK using the right routes, they've made the application within the right timescale. So employers will still see people who are eligible to make late applications.
Okay. So it's as if we haven't had enough of getting our PCR tests. We've now got to go and get a PVN test to work out everything. So let's make sure we get the right tests for our people. So what I'm hearing is that the deadline has passed, the grace period is over, and we've got a new points-based immigration system applying to Europeans, using that sort of broad phrase, in the same way as, frankly, anyone else in the world. So, and I'm also hearing that there are new rules on the right to work checks for Europeans. So, and again, it sounds to me like we roughly got comfortable with the old system, and there've now been changes. So, what are the key changes there?
In terms of the right to work changes, I think the first thing to be clear on is that the basic premise of conducting right to work checks hasn't changed at all. So employers must continue to carry out right to work checks before an individual starts employment. And then the general requirements to obtain a relevant ID document, check it, copy it, retain copies, remain the same. And we're not going to go into all of that in detail right now, but that is still the position. What has changed as a result of all of the revisions to EU work, as you just mentioned, Andrew, is that the types of documents that are now acceptable to demonstrate the right of work are different. So there is still the list A and the list B that lots of people will be familiar with. As before, list A is for documents which demonstrate the indefinite ongoing right to work for the duration of the employment without any need for follow-up checks to be undertaken. List B, on the other hand, still creates a temporary statutory excuse, and a repeat check will be required before the document expires. And a statutory excuse, just for anybody who isn't familiar with the terminology, is effectively the immunity from civil penalties relating to illegal working that is available to those who've done a compliant right to work check. The most important thing to note is that because of the changes to the rights of EU nationals, European passports and national identity cards are no longer suitable right to work documents in of themselves, unless they contain another immigration permission within them. So whereas previously, for lots of employers, the main ID document, the main right to work document you would see from people was either a UK or a European passport, now it's only a UK or Irish passport or ID card, which in of themselves are sufficient right to work. In most cases, what is going to be required, certainly for EU nationals, is evidence of status under the settlement scheme or evidence of a pending application. There are some other changes to the lists of eligible documents. So, for example, Irish passports and ID cards have now been added as a List A document, as the one exception to European passports no longer being acceptable. And that's because Irish nationals still have the right to live and work as they previously did due to separate arrangements with Ireland. A brand new immigration permission known as a frontier worker permit has been introduced and added to List B. And then various documents which employers will have become very familiar with accepting as evidence of right to work, such as permanent residence cards, are no longer acceptable and have been removed from both lists. And in most cases, like I said, what is actually required from European nationals will be demonstration of settled or pre-settled status or an alternative legal right to be living and working in the UK.
Okay, so that's quite a sobering list and assessment, isn't it? So a lot of change. It sounds like frankly, every employer has got a lot to get to grips with. So what practical actions should employers be taking sort of now, I guess?
So I think there's lots of things that employers should be doing in practice, if they haven't already done them, just to make sure that they're continuing to carry out compliant right to work checks and continuing to benefit from the statutory excuse. So, for example, the most obvious thing I think is making sure that policies and procedures which relate to right to work checks are updated to reflect the acceptable documents that are now in the Home Office guidance. And then secondly, linked to that, is actually then drawing those changes to the attention of relevant staff within the business who actually carry out right to work checks. So if you're a recruitment manager, you're a HR manager, and you've been doing right to work checks for 10, 20 years, you're not going to be looking at the policy every time somebody presents a European passport. Effectively, you're just going to take on face value that that's acceptable. So I think it's really important to have that clear communication with the relevant personnel. I think the other thing that's important is to make sure that employees who do right to work checks are familiar with the various different categories of right to work checks which are now available. So you've got your manual right to work checks, you've got online right to work checks, and you've got using the employer checking service. The Home Office has recently published its intention to further digitalise the immigration system and the visa process system. So while at the moment it's primarily European nationals who are evidencing their right to work digitally, certainly in the future the intention is that will be expanded to nationals of other countries as well. So now's a really good time just to be rolling out the relevant training. I think the other thing, just linking back to what we were talking about with the transitional measures, is communicate to any existing European employees, to make sure that anybody who hasn't made the application is first identified, and then that they are taken through the transitional measures to put an application into the settlement scheme within that 28-day period. I think in terms of practical tips, another thing that lots of employers should be thinking about is whether there is a need to do retrospective checking at this stage. So the Home Office has been quite clear that retrospective checking of EU nationals who provided their right to work checks at the outset of employment isn't mandatory. But actually, if you're an employer and you think, I'm not quite sure whether we've always done what we need to do in terms of right to work checks, then now might be a good natural opportunity to roll out right to work retrospective checking. Again, that comes with a massive health warning in terms of not being discriminatory, not picking out European nationals and only checking them. If mandatory checks are undertaken, it needs to be done for everybody. And then the obvious thing, I guess, is if you do have somebody who makes an application for a job, they haven't made an application under the EU settlement scheme and they haven't got an alternative legal right to be in the UK, then obviously think twice before employing them, because fundamentally they may well not have the right to live and work in the UK. But again, there is a bit of a health warning there because you need to be careful not to be discriminatory. You need to be careful to make sure you ask the questions at the same stage in the process for whoever is making the job application. And then I think just finally, touching on practical tips, if you do have people in the organisation who have pre-settled status and not settled status, I think it's a good idea to diarise somewhere to flag within your right to work systems when that person might become eligible for settled status. So you can effectively shoehorn them into settled status as soon as possible, get them off this list B, need to do a repeat check, and onto list A, no need to do a repeat check.
Okay, so again, it's to an extent it's building on the knowledge we had before, but doing it better and slightly differently, and more importantly. Okay, so let's take a slightly different tack because we're 19 minutes in and we haven't mentioned COVID. So we've got to mention COVID. What about that? Because I know that the government did allow a bit more sort of leeway, some adjusted right to work checks. Are those sort of things still in place?
Yes, so the adjusted right to work checks have actually been extended up until the 31st of August of this year. So checks can continue to be done remotely for the time being. For anyone who isn't familiar with what the adjusted right to work checks are, these effectively enable employers to conduct right to work checks using scanned ID documents and with the person at the other end of a video call as opposed to in person. As opposed to in their physical presence, I guess. These adjusted checks were initially due to expire at the end of June, or on the 19th of June when the lockdown was meant to end. They've now been extended until the end of August.
Yeah, okay. Thank you for that. Depending on which paper you read, we're either coming out of COVID or we're heading into a dark place. So hopefully we don't have to mention COVID too often. You mentioned frontier worker permits, and again, that's a new thing as far as I can tell. What are they all about?
Okay, so frontier worker permits are effectively a brand new immigration permission. So in a similar vein to the European settlement scheme, which protects the residency rights of EU nationals who were resident in the UK as at the end of the Brexit transition period, frontier permits, in contrast, apply to European nationals who are not resident in the UK, but who come to the UK regularly for work. And by regularly, I mean they must come to the UK at least once every 12 months, where that arrangement of them coming to the UK for work was in place as at the end of last year. So provided that the individual can show that they're coming to the UK to do genuine and effective work, that they're a European national and that they're not primarily resident in the UK, then they should be eligible for one of these frontier worker permits. And in practice, we've seen lots of employers and lots of clients making use of this because it's obviously a much more straightforward process than trying to sponsor somebody. Again, while there was this 6-month grace period, so in the same way that EU nationals could continue living up until the end of June without the need to make an application under the settlement scheme, frontier workers have thus far been allowed to continue coming into the UK as a frontier worker without the specific permit in place. But that changed from the 1st of July. So from the 1st of July, they need to have made their application as a frontier worker. So again, if you do have these individuals within the organisation, now is the time to be identifying them and making sure that the relevant applications are made.
Okay, and you mentioned sponsorship. I'm going to flick over to Katerina shortly on that, but just I think there's a final point in my mind is, what about if you're just a normal European national, you want to visit the UK, can they just come in? What is the position on it? Someone just want to come in?
So yeah, European citizens can continue to come to the UK for holidays or for short trips of up to 6 months. And that includes for some business purposes without the need to apply for an advance visit visa. They effectively make their visa application at the border when they enter the UK. But I think the key thing for employers to bear in mind is that whereas previously there were absolutely no restrictions on what European nationals could do when they came to the UK, now, if they're not sponsored under the points-based system, and if they don't have another immigration permission, such as status under the EU settlement scheme, then they will need to ensure that they're complying with the requirements of the visitor route. And for business purposes, that does permit certain very limited business activities, but there are parameters around what's permitted. And most significantly for employers, the visitor route doesn't allow productive work in the UK. And I know Katerina is going to come on and talk about this in more detail, but at a headline level, that's, I think, the key message employers need to get their heads around.
Okay, that's really helpful. So, Katerina, it sort of segues into you, because I know that you've been looking at a lot of the stuff to do with sponsorship. So, Shabana seems to be telling me that if a European person wants to come here and do proper work, do a job, whatever it is, they need to do sponsorship. Is that correct? And what's that about?
So that's correct, Andrew. So with previous free movement rights for Europeans essentially fading into memory now, we now have this main route for non-British and Irish nationals wanting to come to the UK. So that's now the skilled worker visa and the intercompany transfer visa. There are a few other routes for temporary workers, but these are the two routes that we're going to cover mostly today. So the skilled worker visa is a sponsorship system. It basically overseas workers cannot simply come to the UK and work without a visa. So applicants do need a job offer from an employer that holds a sponsor license in order to legally work in the UK.
Okay, so again, the obvious question to me then, where do I get a sponsor license from? What do I do?
So it's an online application. So it's on an online form using the government website. But before you decide to make an application, you need to start thinking to yourself, do I meet certain suitability and eligibility criteria? So you need to be thinking to yourself, am I an honest, dependable, reliable employer? Can I provide a genuine vacancy of employment to a migrant worker? So employers are held to quite a high standard when they do obtain a sponsor license, and the Home Office does expect the employer to take some of the administrative burden essentially in trying to tackle illegal migration, illegal working in the UK. So they're expected to ensure that their workers are compliant, that the employer themselves is compliant with the sponsor license, just ensuring that you're meeting the immigration rules. So it is quite an onerous obligation on sponsors in terms of monitoring and reporting on their sponsored workers. And for example, if you were to come across a sponsored worker who's not compliant with his or her duties under the license, you should be notifying the Home Office immediately of that. You will also need some supporting documentation when you make the application online. So these documents, fortunately, particularly in times of COVID, they can now be submitted electronically. So you can either send a PDF document, a scanned copy, but we do recommend to employers that you keep that original documentation because the Home Office might request it in the future.
Okay. And I guess what sort of documents do we need to gather together?
So when submitting the application form online, there's quite a few different types of documentation you can provide, and that will depend on the type of organisation that you are, whether you're a franchise, for example, or a startup. But just in terms of a general list that might be acceptable, so a certificate of VAT registration, evidence of registration as employer with HMRC, proof of ownership of a lease or a business premises. But again, there is a list online that shows you the types of documentation that you can rely on.
Okay, that's helpful. And you mentioned that there's going to be some sort of admin, and so therefore that means people doing things within the business. So what sort of people have we got to line up within the business to, I suppose, either get the license and then once you've got it, keep it? What sort of people do we need?
So that's true. So you're going to have to get a couple of people within your team to help you manage the sponsor license. So you're going to, even when you do obtain your sponsor license, it is a continuing obligation under the license to ensure compliance, basically. So just going through the types of people you're going to need in your organisation. The first person is the authorising officer. So that should be a senior member of your team, someone who's probably involved with HR, with recruitment, because they are ultimately responsible for the license, and they're going to ensure that the duties under the license are met. You're also going to need a key contact, so that's just the main point of call to the Home Office in terms of correspondence, and that can also be a legal representative if you wanted to appoint a legal rep. And finally, you're going to need a level 1 user. So this person is probably going to be the most important in terms of day-to-day management of the system, because they have access to what's called the sponsorship management system, the SMS. And what employers should really be doing is having more than one level 1 user, so either a level 1 and a level 2 user. This would help because you may have someone who's on annual leave, so you need to just make sure you've got cover, just to make sure someone always has access to that system. Or for example, the level 1 user leaves the business and you suddenly don't have access to the SMS. So it's very important that you have more than one person on that as a level 1 user. And finally, I would recommend that you have a chat with the personnel that you are deciding to use as key personnel, because you do need to ensure that they don't have any unspent criminal convictions. So maybe just explain to them the reason why you're asking that question as well.
Okay. So again, who's checking all this? Who's going to mark my business's homework?
So the Home Office themselves complete compliance visits.
Oh gosh, right. Okay. Yeah.
So it's for the Home Office to confirm. They're going to decide whether or not you are someone who's as I was saying, a genuine, reliable sponsor. So they will either be coming to the sites, the place of work, either before the license is granted and or after. So always make sure that you've got, procedures in place. If you do have time as well, we do recommend that you maybe have some kind of mock check on the types of policies and procedures that you have in place, just to make sure that you are compliant before you make that application.
Okay, no, that sounds sensible. So if we're getting to the place where it seems to my mind that Europeans are basically being assessed in the same way as everyone else across the world, and you talked about the whole concept of sponsoring skilled workers, are there any changes as to how that's working in practice and what the criteria are, those sort of things?
So the skilled worker route specifically is definitely more flexible in comparison to the other points-based immigration system routes. So it allows people with different qualifications, salaries and skills to obtain a visa to come and work in the UK. So just in terms of the previous system, so there was different terminology previously. So the skilled worker route that we know now was previously called the Tier 2 General Visa. And also the Tier 2 intercompany transfer is now just the intercompany transfer route. And that covers, so that's the ICT route, just shortening it down. So it covers intercompany transfers and also intercompany graduate trainees. So all this terminology has just shifted onto the sponsor license, the actual list of sponsor license holders. They've all just been converted to skilled workers. There's not been any admin for that. It's just been automatic.
Okay. Cool.
So sorry. So there's just a few more changes, I'd say, to the way that the points-based system has changed. So in terms of if you wanted to apply for, say if you're a visa national or a non-visa national and wants to come to the UK to work, you're going to need to obtain a certain amount of points in order to apply for a visa. So if it's the skilled worker route, it's 70 points in total, and the first 50 of those points are mandatory points. So they're obtained firstly by actually obtaining some form of sponsorship. So you'll have a sponsor license, they will issue you with a certificate of sponsorship, and that will grant you your first 20 points. You're then also going to need a job at an appropriate skill level. So currently the skill level for skilled workers is level 3 of the recommended qualification framework. So that's essentially A levels, which is significantly lower than the previous system, which was RQF level 6. So that was graduate level. And then you're going to need, for an extra 10 points, is English language at level B1 of the Common European Framework for Languages. So you need to show proficiency in English language. So you can either do that by showing that you're you take a level 1 test, or you show that you're a national of a majority English language speaking country, or you can also show the proficiency by showing the Home Office that you met it in a previous application to the Home Office. So in terms of more changes to the system, skilled worker route, there's also been a reduction in the minimum salary that sponsored migrants are going to need to be earning per year. So it was previously 30,000, roughly £30,000 a year. Now it's 25,600. So that just reflects the expansion in the roles and the ability to trade points, as I was mentioning earlier. So for example, you may have a job in a shortage occupation role, for example, a nurse, or where you're an individual who has a PhD in a relevant subject. And this also includes STEM subjects, so science, technology, engineering, and maths. And there's, as I was saying, because there's been a reduction in the skill level, so we've gone from degree level to A levels, that has just opened up the, it's created more of a level playing field for migrant workers.
So that's helpful. So maybe just put some flesh on these bones. Give me some examples of job roles which you could now get sponsored in, whereas previously you couldn't. I appreciate it'd be dependent on salary levels and those sort of things, but just give us some examples.
So just as an example of jobs that can now be sponsored. So for example, if you're in the construction industry, you have builders, carpenters, welders, plumbers, electricians. If you're in the retail leisure sector, we have sales supervisors, sales administrators, warehouse and logistic managers. In the food and drink industry, we have chefs, butchers, bakers, and there's also been a wide range of technicians that are now able to be sponsored. So laboratory and IT technicians, medical and dental technicians, and even photographers are now under
Even
that route as well.
photographers.
Even photographers. So it really has opened it up.
Yeah.
And also just as a side note, we've now also seen a removal of what's called the residential labour market test.
Okay.
So that was used in the past to guarantee that settled workers, say British nationals or someone with indefinite leave to remain, would get preference over migrants if both the candidates met the requirements of the advertised role. So this is no longer the case, because there's more opportunities for sponsored migrant workers. So it's just you're allowed to sponsor these people rather than just relying on the local labour market.
Okay, that's helpful. So maybe just a few more things. But again, you talked about the intercompany transfer route. What are the key differences there? What do I need to know?
So this basically enables businesses with linked entities overseas to transfer employees to work in the UK and in their UK offices. But we are likely to see a reduction in the use of this route just due to the flexibility afforded to skilled workers, the skilled worker visa. And the government is currently considering changes to this route, but we haven't seen any changes as yet, but we are keeping up to date with that. You'll also, it's quite a high level that's expected of you under this route. So you're going to need to be at, as I was mentioning, the RQF level. So you do have to be at least degree level to be applying for sponsored roles under this route. You're also, just in general, you're going to need to be earning at least 41,500 a year. That again, there's a few exceptions to that, but generally it is quite a high threshold. You're also going to need to be working with that overseas entity for at least for a certain period of time before you make an application to come work in the UK. But the good thing about this type of visa route is that you don't need the English language like you do with the skilled worker visa.
Okay. Yep.
So obviously that's going to be an advantage to employers who need someone to come to the UK straight away, not needing to show English language proficiency and just coming straight in. But just as a caveat to this point as well, the ICT route doesn't lead to settlement in the UK, unlike the skilled worker visa. So the applicants will need to, if they were looking to eventually settle in the UK, they maybe need to be looking at switching to the skilled worker routes, and also you'd need to be meeting that eligibility criteria. So unlike the skilled worker visa, there are less points to meet, but all points are mandatory under the ICT route. So again, you're going to need sponsorship, that's 20 points, job at the appropriate skill level, and you're also going to need to be earning a certain salary as well.
Okay. That's helpful. I think the final question I've got, I'm sort of thinking, I've got sort of client things in my head, thinking that the client's going to be saying that I really can't be bothered getting a sponsor license. I don't like talking to lawyers, too much paperwork. How I need to get, I don't know, an IT person in from Germany. What? Give me some other routes. What can I do?
So an option for you potentially, as Shabana was mentioning, you can come to the UK as a visitor under certain permitted activities. So say, for example, you're a European national, obviously you're a non-visa national, you can come to the UK for up to 6 months without being required to apply for that visitor visa previously. There is a condition on that you must not work in the UK unless you are permitted to do, certain activities, for example, intracorporate activities. So I think the main message is you must be a genuine visitor when entering the UK, showing that you are genuinely seeking entry for the purposes that are allowed under the visitor route. But in terms of examples of, essentially exemptions to that rule, so you could be coming to the UK for a permitted paid engagement. So this is it's more for people that are experts in the field and they're coming to the UK for a specific prepaid engagement, and that you can be in the UK for up to 1 month doing that. If you were just going back to your point about technicians and things like that coming to the UK, so you are permitted to enter the UK under what's called intercorporate activities, permitted intercorporate activities. So you can come to the UK for specific purposes such as advising, consulting, troubleshooting, providing training, sharing skills and knowledge, but you must be here on a specific internal project with UK employees of the same corporate group. So that does narrow down the types of people that that would be allowed to enter the UK, because you're not really supposed to be carrying out work directly with clients if you're coming under that category. And just in terms of general business activity that's permitted, if you were to come to the UK on a visitor visa, you can attend meetings, you can attend conferences and seminars, you can carry out site visits, for example, you carry out site inspections. But again, this business activity that you're undertaking, it does normally need to be linked with the visitor's employment overseas. So, it has to be incidental to your overseas employment, and you can keep in contact with your employer overseas while you're undertaking that. But if you think that you're going to be moving away from that, and you feel like you may be fulfilling an employed role in the UK, then we would be recommending that your employer looks at the points-based system and potentially looking at the skilled worker and the ICT route. And there's a reason for that. So especially for Europeans now, we do feel like we're going to see a lot more Europeans being checked at the border coming in, particularly after, as Shabana mentioned, we're now at the end of the grace period. So those that are intending to arrive under permitted activities are probably going to face much closer scrutiny and potential refusal at the border as well. So it's a very subjective test. We would be saying to people, just ensure that you are being genuine and telling the border officials exactly what your intentions are in the UK, because that can have quite serious consequences if you are refused entry at the border. So that can potentially adversely affect any future applications that you intend to make to enter the UK. It can it can trigger a re-entry ban. It can frustrate business objectives. And just the final point, there is no right of appeal against a visit visa. You just need to really be thinking about these things before you decide to enter the UK for permitted activities.
Okay, it's a lot to digest.
Yeah, and I think actually the key messages that I take away from everything we've said so far, or that I think people need to take away from what I've said so far, are firstly, that the right to work processes for European nationals are now very different. The types of permissions they need to work in the UK are now very different. And every business, I think, within the UK will need to reflect on the new requirements and work out that they are adequately reflected in their own practices. And the second really key point, I think, is businesses who don't currently have a sponsor license because they've never needed one to sponsor European nationals before because they didn't need to be sponsored, really do now need to be thinking about applying for a sponsor license as soon as possible, because ultimately, if an application isn't made until there is a need to bring somebody in, then inevitably the process takes some time, and that will potentially delay any recruitment process. And the Home Office itself is encouraging a preemptive approach and saying, look, make the application because the likelihood is at some point you will need a license to sponsor European workers. And I think actually in the last few minutes, it would be really helpful if we could look at workforce management issues. So issues about managing remote workers, including workers from overseas, because that's an issue which I think lots of employers are facing at the moment. Andrew, what are you seeing in relation to this trend, if I can call it a trend, of remote working and potentially remote overseas working?
Well, it's more of a reality than a trend, isn't it? We're all, well, mainly remote today for various reasons, so we've been doing it. I think every employer is, not every, but the vast majority is grappling with it. It's a difficult issue. I think the messages that are coming through from talking to clients in many different industries are, you've got to grapple with it. When we all left the building, we think back to 23rd of March last year, or whenever it was all like pick up your bags and go, and no one complained. They just got on with it. Now we're coming back, it's actually slightly more painful because everyone's going, what about this, what about that? And that's fine because we're doing it more slowly in a more considered way. But I think the other implication of that, I'm saying to clients and clients are saying to me, is the decisions you made when everyone was running out of the building was like, well, just go. You knew it was temporary. Now the decisions we're making about where people can work are going to be more permanent, and that means you've got to give it a lot more thought. And I think then that we know, well, maybe we don't know, and that's actually part of the problem. As businesses, do we know where people are working at the moment? Yeah, some days in the office, some days in the UK, some days out of the UK, because over the last few months, everyone's saying, don't care, just get the job done. But now we need to be saying, is that appropriate? I think in relation to servicing your business, because again, take our business, we haven't really had many clients in the building, so it doesn't really matter. But that's going to be changing. We hope and believe. We all want to see people. So therefore, there's a greater onus for people to have the ability to be physically in the office. Not all the time necessarily, but a lot of the time. Secondly, so you've got the relationship with the clients, customers, whatever you call them. Secondly, you've got to be fair to your colleagues, haven't you? So if I've chosen to work in the south of France, to be clear, I'm not. How is that being determined? What if everyone wants to work in the south of France? How on earth are we going to unravel all of that? Because frankly, if you're not managing people, you're going to have a management problem. People are going to say it's unfair, it's discriminatory, all those things. That's also leading to interesting discussions about pay. We're not talking posted worker directives here, but it has sort of similarities. And then we're saying, what is the market rate? Is that going to lead on to, we're just about getting our heads around gender pay reporting. Is that going to happen into race pay reporting? Don't know, but people are talking about it. So there's issues to grapple with there. I think the other points I would mention are, this is a genuinely interesting area because it's multidisciplinary. Okay, we've got to think about HR issues. We've got to think about employment law issues. We've got to think about tax, health and safety, data, the dreaded GDPR, reward, retention, immigration. So again, we've done webinars on this and we can share the links, this, that and the other. But it's, what about the health and safety at work, at home, even before we get into COVID, but those sort of things. Data, is it acceptable to have people, documents lying around on the kitchen table? Bigger risk that needs dealing with, and we all see the cases to do with data breaches. Blurring of work-life boundaries, big issue. We've all seen articles about, the right to disconnect. Are we going to wait for the government to do something? They probably will do something, or do our employers, getting ahead employers are actually trying to get ahead and take that as a win to look after their staff. Difficult, but we need to be grappling with that. You're always embarrassed talking about policies because it sounds quite boring, but I do think we need it here because policies are very linked to training, and the bottom line is no one knows what we're doing. We're all fumbling around in the dark. So therefore, if we don't have policies and training, everyone's going to be doing everything differently, and that causes a problem, not least because people will then say, well, I've been doing it for 6 months, why on earth should I come in? So having some unified policy, I think, is very important, and then training people. And I think the final point I'm going to mention is a little bit odd, but you're heading into big tax problems if people are working abroad. So if they're working in the UK, that's fine. They're doing their work in the UK. It goes through PAYE brackets, assuming they're employees, and you haven't got an Uber type problem. If they're working abroad, well, where are they doing the work? Interesting legal philosophical question. But in the world where every tax authority is looking to gather some money, they're going to be looking at two things. One, if Fred is working in France, should Fred be paying social security taxes if they're using the system? Or, again, assuming Fred has got the right to be there, is he using the system? Therefore, he should be paying social security taxes. Secondly, should he be paying income taxes? Thirdly, perhaps more importantly, from a corporate perspective, this is concept. Look, I'm an employment lawyer who knows a bit about tax, but the point is, if you are doing business in another country, you can create what's known as a taxable presence. That can have big corporate impact. So allowing someone to be flexible and working abroad can cause you big corporate issues. And that's why some of the big employers are rowing back a bit and going, I'm not sure we can let you work anywhere. Perhaps because of management issues, but also because of big financial tax type issues. So I think, what should employers be thinking about? The plan you're putting forward or doing, is it a good balance between the needs of the business and the worker? Is the policy fair and non-discriminatory? Remember, indirect discrimination, obviously. Have we ticked all the boxes for health and safety, GDPR? Tax stuff, as I've talked about. And I suppose the other thing, just I'll throw back to you, Shabana, is, if I'm allowing Fred to work in France, Singapore, wherever it is that going to mess up UK immigration status?
Yes, I think that's a really interesting point. I think if Fred is a sponsored worker and he's here under a sponsor license, then there are potential issues there in terms of if the Home Office guidance doesn't expressly prevent somebody who's sponsored going and working abroad temporarily for short term, especially during the pandemic, there was a lot more flexibility. But certainly in terms of longer term arrangements, if somebody's in the UK as a sponsored worker, but then actually decides to go and work in another country, then I think there are real question marks in terms of, is there actually a genuine vacancy in the UK that requires sponsorship? Because actually, if you don't need to be in the UK to do the work, one of the requirements of sponsoring is that the vacancy itself is genuine. So I think that's a concern. The other issue is, how on earth do you navigate your responsibilities as a sponsor license holder in terms of monitoring the individual, reporting on them, if they're actually sat at the other side of the world? So I think even if it's going to be a temporary measure, you need to think creatively in terms of how are we actually going to maintain our sponsor license obligations during this time. And this is something which in reality is happening. I've seen queries from clients where they do have sponsored workers who want to go, who have wanted to go and work back home during the pandemic. So I think there are lots of issues to consider when that's before putting that kind of an arrangement in place for anybody sponsored. I think it would raise some red flags that need careful consideration. And the other thing to bear in mind, just from the individual's perspective, is if they are intending to apply for indefinite leave to remain. So if they're here as a skilled worker and they're thinking, well, after 5 years, I'm going to be eligible for indefinite leave to remain and get a permanent settlement status in the UK, any time spent outside of the UK is going to be counted towards their residence, towards the residence requirements. So if they do spend lots of time outside of the UK, then that could actually come back to haunt them when it comes to an indefinite leave application. So I think all of those are relevant considerations where the individual is a sponsored worker. But equally, even if they're not a sponsored worker, so you have a UK national who wants to go and work abroad, you do need to be thinking as the employer about, well, what immigration permissions are they going to be working under in the country abroad? So if they're wanting to go back to a country of which they're a national, then you would assume that because of their nationality, they have the right to live and work. But if they want to go and work in the south of France, for example, but they're actually a national of the US, well, they need to have the appropriate immigration permissions to work in the south of France. And visitor visas, like Katrina mentioned earlier, generally across the globe don't allow for productive work. So you will need to be looking at what is the relevant immigration permission there. And actually, just as a matter of general interest, there are some countries now increasingly who are introducing what are known as digital nomad visas. So countries such as Dubai, some of the Caribbean islands, Bali, are actually introducing visas specifically for people who want to do just this, which is live and work in their country for an overseas employer. So I think that gives us a flavour for where governments across the world see this trend going in the future. It is likely to become more prevalent.
I'm happy to sign up for one in Bali if you can help me. Okay, no, that's really helpful. So because in the last couple of minutes, we have got some questions coming through. We won't be able to get through all of them, but I think one for Katrina, one here about, basically, I want to make a sponsor license. What sort of timeline is the Home Office taking on it at the moment?
So it depends. So if you put in just a standard sponsor license application to the Home Office, that can take up to 8 weeks for a decision to be made. But there is also a fast track option. So that's for a fee of £500, and that basically puts in the application for a decision within 10 working days. But just in our experience, we have seen this fast track service, it's more of a priority service. So, they're only looking, the Home Office decision makers are only looking at the first 10 applications in that day. So if you are an employer, just be cautious of the fact that if you are looking for an expedited decision, there's no absolute guarantee, but I think the Home Office are still trying to work to those timescales.
Okay, now that's helpful. I think in terms of the other questions which have come through, what we'll do is we'll drop people a line on those. Secondly, I think we need to wrap up. I've learned a lot. I hope others have as well. For those who missed it, there will be a recording available. There's going to be a summary document as well, which we can circulate. If you want other resources which we've referred to, it's on our Walker Morris website, and there's a dedicated immigration hub. And there's also a future world of work hub, because as you can see, these sort of issues are overlapping. We're also going to be doing another session sort of in September, so look out for that. These issues are going to be touched on again, because these issues are not going to go away, and frankly, the government is bound to have issued yet more guidance between now and then, so there's more stuff to be going at. We're also putting quite a lot of stuff out on LinkedIn, those sort of things. And it seems to me, that clients, what they need to be doing, what I'm saying to clients, what I've learned from here is, I think, one, check the people you've got here already. Are they allowed to be here? As Shabana and Katrina have said, it's basically what you should have been doing anyway, but use it as a reason to say, look, I really ought to do it now. Secondly, if you think you might need a non-UK person here, you give some serious thought about how you're going to get them here. Sponsor license, frontier workers, that sort of stuff. And I guess if you've got people who haven't sorted settled status, really get on with that like today, because the shutter is coming down very quickly. And I guess if you have got people working remotely in or out of the UK, give some serious thought about how you're managing those various risks. You know, discrimination, fairness, health and safety, GDPR, immigration, tax, all that long list of stuff, and it all pulls together. So look, it's 10 o'clock. I've very much enjoyed it. Thank you to Shabana, Katerina. See you again. Let's be brave. Let's dream that we could meet personally, but that's in Boris's hands, which is a scary thought. So have a good day. Thank you.
Thank you.
Thanks, everyone.